This program is brought to you by Emory University.
My name is Adam Knowles. I recently completed a PhD at the New School for Social Research in the Department of Philosophy, working on Heidegger. I joined the Vulnerability in Human Condition Initiative hosted by the Feminism and Legal Theory Project in January 2014. So I've been here for approximately 3 months. And I came here to pursue work on the question of silence and law. I began a bachelor's at the University of Texas at Austin, working on philosophy and history. I've always sort of bridged the two different disciplines. I shifted from there to Heidelberg University in Germany, completed a master's at Heidelberg University, specializing once again on history, specifically South Asian history, where I specifically worked with post-colonial theory, but also in continental philosophy. As I began my PhD, I decided to focus on philosophy. I entered the New School for Social Research in 2008, and as I said, in November 2013, I completed my dissertation specializing on the role of silence in the work of Martin Heidegger, one of the most influential philosophers of the 20th century, most commonly known as a representative of the phenomenological tradition and the existential tradition. Yeah, so let me begin by going back a little bit to tell you what I did in my dissertation and how that relates to what I'm doing now. So I focused on the role of silence in the work of Heidegger, as I said, and silence really becomes, in my reading of Heidegger, becomes one of the central terms in Heidegger's work, beginning in the 1930s. And I argue that that happens through his historical reading of the ancient Greeks. And what Heidegger helps us develop is a conception of silence that I think has two fundamental attributes. That firstly, for Heidegger, silence is not the absence of language, as we commonly think of it. It's not nothingness, but instead silence is the presence of the absence of language. That's the first sort of attribute of silence that I draw from Heidegger. The second attribute is that silence is, for Heidegger, quite often is not merely associated with disenfranchisement or disempowerment, but instead can be something that you're empowered with. It's it's a power that you're granted. It expands power in some ways. And just to give a couple examples, you could think of the way the law is always so uncannily or eerily silent in the works of Franz Kafka. The law never says anything. So silence becomes empowering for the law. Likewise, in the work of Michel Foucault, this sort of empowering silence is associated with the priest in the confession. It's associated with the analyst in the psychoanalytic setting, or with the police in an interrogation setting. So my work, I try to take what in Heidegger is this abstract analysis of silence, sort of silence in this abstract sense, and I try to find practical applications for these ideas that Heidegger has. I came to sort of recognize the limitations of Heidegger's thinking, that he's a profound thinker of silence, but not a profound thinker of silences. Silences in the plural. So what I've been trying to do is move into the question of how can we apply these ideas to particular silences. And I could have taken that work in many different directions. Silence is a major theme in 20th century literature, for example. Likewise in 20th century music. But I think one of the most practical, acute ways that we can approach the question of silence is through the right to remain silent. What does it mean for our legal system to guarantee a right to remain silent? And if it does guarantee a right to remain silent, can we assume that the law understands what silence is? These are sort of the framing questions I'm approaching. If the law assumes what silence is, then what does the law think that silence is? Yeah, it's been interesting as my sort of traditional philosophical training, as I've approached the unique way that the law sort of produces itself through decisions and judicial decisions and legal cases. What I've found is that the biggest challenge is that the law doesn't, in fact, define silence, that it's charged with the task of identifying silences, of deciding in what cases the right to remain silent has been observed, deciding in what cases it's been violated. And the law, judges are very good at deciding these issues and sort of working out instances of silence. Yet this often happens in the absence of a specific definition of silence. So the law is sort of finely attuned to the question of silence, yet it's attuned to the question of silence without operating with a specific definition of silence. So my greatest challenge has been to see how the law bridges this gap between the sort of universal and the particular. The particular instances of silence have to be decided upon in the absence of a specific definition of what silence is. Yeah, so as I said, I was interested in the ways that Heidegger's abstract philosophy of language could be applied in practical purposes. And it struck me that we live in a time where perhaps one can raise the question of whether or not the right to remain silent is at a crisis. Is it being threatened? And in a post 9/11 world, in this country, we have an increased acceptance of torture, so-called enhanced interrogation techniques. The victims of this torture are not granted a right to remain silent. And then we can think of the sort of more quotidian ways that certain populations are criminalized in the stop and frisk tactics that are, of course, heavily debated in New York. So it seemed to me that we might be at a time where the question needs to be raised, is the right to remain silent being threatened? So this is why I turned to the Miranda question. And as I have begun my research over the last few months, so it's now late March and I entered the program in January, I've not only discovered that it's necessary to work on the right to remain silent, but I've expanded the work to cover those times when we don't have a right to remain silent, specifically grand jury summonses, grand jury subpoena, where we're specifically, the person under subpoena is specifically under an injunction to speak. So my research is now sort of mitigates between these two different poles, the right to remain silent, which protects our rights against self-incrimination, and those instances where we have no right to remain silent and we can actually be compelled to speak. And this really came to me in a February 2014 decision, a recent decision in a district court in New York. A man named Gerald Koch, he was, curiously enough, a student of the New School where I did my dissertation. He was a self-professed anarchist. He was called to testify under grand jury summons because he purportedly knew something about a terrorist plot in Times Square. He invoked his right to remain silent and refused to offer testimony in this grand jury summons. And he was imprisoned in order to compel him to testify. And as I began to read in the law is, under such cases, can be coercive but not punitive. You can coerce someone subpoenaed by a grand jury to not be silent, but you can't punish them for being silent. So this Gerald Koch was imprisoned for 8 months. His initial reason for imprisonment was that he refused to speak, but then in the decision that eventually released him, the judge decided that further incarceration would not compel him to speak. That his silence was so recalcitrant that continuing to keep him in custody wouldn't compel him to speak. So on the one hand, his silence was the reason for his incarceration, but then because his silence was so deeply entrenched, the judge decided that he had to be released because you can't be punished for being silent under such instances. So my work is inhabiting the space between these two different understandings of silence, which are, of course, very different, and they play out very differently in individual cases in very interesting ways. Vulnerability theory, as I began to read into it, is very deeply aligned with a number of the philosophical schools of thought that I was trained in. So Heidegger, as I said, is one of the most important representatives of phenomenology. And beginning with Heidegger's works in the early 1920s, Heidegger begins to call into question the sovereign, autonomous subject. So what Martha Feynman in her work calls the vulnerable subject, Heidegger's showing that at an ontological level, at the level of sort of the being of the person, the being of the self, that we're not merely encapsulated, autonomous subjects who can act sovereignly in a world, but instead that we're, as Heidegger calls it, we're open to the world. So the personhood is an opening. One of Heidegger's great readers, the philosopher Jean-Luc Nancy, calls this exposure. We're exposed to the world. So what it means to be a person is to be exposed to the world. So what the phenomenological tradition has been doing for almost 100 years now, at this ontological level of the question of the person, I think is captured in a very fine and subtle and practical way by Professor Feynman's approach to vulnerability. And I think I draw a number of aspects from vulnerability, but perhaps 3 of them would be most important. That vulnerability is the human condition. It's not merely episodic. It's not something that comes and goes. It can be heightened in particular situations, but it's a fundamental human condition. And secondly, that vulnerability is both universal and particular. We're all vulnerable, yet each of us are vulnerable in a particular way. And lastly, what I think I draw is that from Professor Feynman's understanding of vulnerability is that vulnerability is not something to be overcome. We're not working towards a non-vulnerable state of sovereignty or autonomy, but instead vulnerability is something to be understood, not overcome, but understood. And I think these 3 aspects apply in a very interesting way to the condition of a position of a suspect who's under interrogation. It's a particularly heightened moment of vulnerability. And what's interesting is about this moment is in that moment, if we understand the suspect as vulnerable in the way Professor Feynman lays it out, that neither the speech nor the silence of the suspect is merely an autonomous, sovereign act of that suspect, which raises interesting questions about what does a right to remain silent mean? What does it mean to guarantee silence? Is a silence that's guaranteed by a right, in fact, impossible? This is the question I want to raise. Likewise, is the speech of the suspect under interrogation equally vulnerable? I think one of the wonderful things about vulnerability theory is that it tries to move away from unhelpful dichotomies, so sovereignty, dependency, and inhabit a space between dichotomies. And I try to do the same thing with the question of speech and silence, that the voice of the suspect is neither a silence that is purely his or her act, nor a speech that is purely his or her act, but inhabits some space in a continuum. And I think the way the law works in applying the Miranda decision, it's acutely aware that it must work on this continuum. Yet it does so in the face of not having a definition of silence. So I'm trying to draw from how the law works, how it applies itself and explains itself, to offer definitions that it implicitly already operates with. What are the ways that silence is understood by how it is applied in decisions regarding silence? And I think vulnerability is a wonderful way to approach that question.